matter of re Q.
Good morning, Mr. Hahn.
May it please you, Lord, and your lordships and your ladyship, I appear on behalf of the appellant in this case, along with my junior, Mr. Alistair Henderson. Ms. Deirdre Foxrell, King's Counsel, and Mr. Tom Wilson appear for the first respondent. And Ms. Alison Munro, King's Counsel, and Ms. Emma Favata appear for the second respondent. The mother and father of the child Q are in court, and the guardian and solicitor are online, attending online. In terms of housekeeping, and so you understand where I'm going, it's agreed at the bar that I aim to be about 2 hours, maybe a little bit more, 2 hours, 2 hours and 15 minutes, but certainly to have finished before lunchtime. And then the respondents will present their case. I start by saying this is a case where Lady Justice King granted permission in terms that are set out in the core bundle at our page 584. And I simply note that the two main points within that grant of permission relate to it being arguable that the proper time to consider bringing the proceedings to an end was following the proposed assessments by Gender GP, and then on the compelling reason ground, there was a compelling reason for the appeal to be heard, in particular as to whether a court could or ever should override the decision of a young person who's over 16 and has capacity consent to treatment which is being offered by a treating doctor in the United Kingdom, in circumstances where the treatment which is being offered privately, whilst not life-saving or sustaining, is irreversible, highly controversial, and could not be provided in accordance with some of the recommendations contained in the CAS review. The appellant argues that this appeal does raise an issue of law of significant public importance, namely the correct approach in law to the best interests of a young person over 16, and, as identified by Lady Justice King, whether a court could or ever should override a capacity to consent which is either presumed or proved, or at least not rebutted. Secondly, the treatment is offered by a UK doctor in the private sector, a reason that I'll come on to by reference both to the serious medical treatment guidance. It's relevant because of the conflict of interest between the doctor.
Well, Mr. Hahn, you were trying to formulate a point of law,
yes,
and now you're sort of verging off into the facts. It would help me anyway if you could just tell me what you say the point of law is in words of, in one sentence.
In what? I'll try and keep it to one sentence.
You said the correct approach in law to the best interest of a person over 16, and whether the court should ever override what?
One, capacity to, Roman 1, capacity to consent.
Yes.
Semicolon, Roman 2,
yeah.
Treatment offered by a UK doctor in the private sector.
Treatment offered by a UK doctor in the private sector.
Yeah. And then semicolon, Roman 3, that while not life-saving or sustaining, is or may be irreversible, comma, highly controversial, and could not be carried out in accordance with some of the recommendations of the CAS review.
So how does the CAS review translate into a point of law?
In very much the same way as when we come to look at the case of Re W, the factual context in which treatment was being given, in that case an anorexia nervosa case, to an individual who was over 16 raise two issues of law which are addressed by the court. The first is whether the court had any jurisdiction at all to override. And the second issue was what the correct approach in law should be to the exercise of discretion within that jurisdiction. That is a legal question.
That's the application of Section 8, which is resolved by this court in Bell.
My Lord,
and we're bound by it.
My Lord, respectfully, the proper approach to the specific facts and the factual matrix in this case are informed by the outcome of the CAS review. And in terms of the...
Sorry, just say that. What's informed by the CAS review?
The proper approach to the exercise of the court's jurisdiction to override.
To override the wishes of the child.
Correct.
Is informed by CAS.
Very much so.
I mean, why... I'm sorry to fire all these questions at you. I promise to shut up in a second. But why is it not the case that CAS is one step in the road of what was said in Bell at the end of the judgment about the clinic that was then in place but is no longer, and that all those questions are for regulators, for Parliament? We saw yesterday the intention to legislate about puberty blockers, which is very much what we said in paragraph 3 of Bell, that this is all for regulation, this is all for CQC, for NHS, for everybody who regulates medical treatment, and not for the court. The court's question under Section 8 is clear from, I think, from VW and also Bell.
My Lord, may I answer that question in two ways, and then seek to try and develop it through the course of my argument.
Yeah.
The first is that Bell is a judicial review decision where one of the important factors material to the court's decision was the absence of any individual facts of cases. It was repeatedly said against the appellant in Bell, capacity is decision-specific and person-specific. The court should not be a general advice centre based on Burke. You must get some facts before you try and advance these arguments. This case...
You got them.
Got facts. That's point one. Point two is what I'm using the label precautionary approach. And if I can explain that in the following way. It is my case, our case, that what the authorities reveal, whether it's REW or REA, the two of the main cases I'm going to go to, and whether it is more than just a power, but a duty of the court to intervene where there's a risk of irreversible harm and or a major step in the child's life is being taken on particular facts.
Irreversible harm or a major step is being taken?
Yes.
I mean, that's very different from my understanding of Section 8 as it's been interpreted.
Well, may I try and show you in the authorities where I get major step in the child's life from and then irreversible harm as well?
I mean, irreversible harm, I think, you know, I personally completely understand. That's precisely the role of the court, if there's irreversible harm. And that is why the Section 8 cases tend to be the reverse of this case. They tend to be a case where the child is refusing treatment.
They do. I fully acknowledge that. We've got a list of similar cases within you're taking to it in one of the respondent skeletons, I think first respondent, I think it's paragraph 61 or 65 of Mumby's decision in HS&X. The life-sustaining treatment type cases, the Jehovah's Witness type cases. Fully alive to that. But on this second issue, the protective jurisdiction, like, 2 sub-points. Firstly, it relates to not just refusals, but positive decisions. So it can apply where the child wants the treatment and the court says, well, really, we don't think that's in your best interest, even though you're capacitous. And clearly that jurisdiction exists, and I don't think it's disputed. And as to the protective part, and this is the reason for the relevance of CAS and the development of cases, if you accept a submission from me that there is a protective role of the court, sometimes referred to throwing a cloak around the child or whatever phrase one chooses to use, then the facts of the development of what has happened since a judicial review was begun at the commencement of the Bell litigation show that real risk of irreversible harm to a large cohort of children happened both at the Tavistock and subsequently by the provision of a treatment that has now been recognised as of yesterday, not just by CAS, but by something called the Commission of Human Medicines, to be unsafe. The thrust of my submission is, and the reason why CAS is really relevant to what I have to say, and I hope to be able, with your leave, to develop why not just why I say it's relevant to the significant parts of it, is because it informs the protective role of the court as to this kind of treatment. It allows me to say, my submission, that this kind of treatment, gender-affirming hormone treatment, is a kind of treatment that is in a special category, which requires, particularly in a case where there is a dispute between those with parental responsibility for the child, to come to court for its adjudication.
You say it's in a special category, notwithstanding that Bell said it wasn't.
Bell said puberty blockers were not in a special category. And I do again advance the special category argument, because I say that I distinguish Bell as being about puberty blockers, where the comparison was drawn, and I'm not going to go to the judgment now, but the comparison is drawn between contraception and termination of pregnancy, those types of procedure, and says it's no different in kind. My argument is that this case is not about puberty blockers, it's about gender-affirming hormones, distinction 1. And distinction 2, there is a huge difference between abortion, termination of pregnancy, clearly life-affecting events in a person's life, and hormones, because the key difference being the absence of evidence in relation to that treatment. So exiguous is the evidence in relation to it that, as I hope to show by reference to the CAS report, only 2 guidelines, that is to say guidelines on gender treatment, pass through the filter of the York University, who assessed them by reference to reliable, sound guidelines, and they were Sweden and Finland. I'll come to this later. The point being, ultimately, that both of those countries say only in research or only exceptionally for gender-affirming treatment, based on the evidence base. And if it is accepted that gender-affirming hormone treatment on the basis of CAS, on the basis of the factual matrix which CAS allows the court to inform its view as to whether it's experimental in that sense, then it does push hormone treatment into special category treatment. A line of authority dating back from James Munby Queen's Counsel as he was in the case of W, and I hope to show you this shortly, advancing this special category argument, and as I'll show, fast forward 30 years to the Vice President's guidance on serious medical treatment, and almost the same list with some subtle changes. And that is clearly an established approach of the Family Court to certain cases where, because of their features, the court takes a much more proactive or protective role towards the child subject to the treatment. Well, I've tried to summarise at the beginning those points. What I was proposing to do with your leave is to sketch out how I propose to put my argument before you. Thank you. The order under appeal, I'm not going to turn it up, but it is, for your reference, is at core bundle, page 20 to 21, is essentially a refusal of an adjournment and the dismissal of proceedings. That is the decision appealed, and as identified by Lady Justice King in her grant of permission, one of the key arguments that the appellant puts forward is that was premature. It prejudged evidence that may or was likely to come out in the course of an envisaged assessment by Gender Plus, which may have opened the door to the court exercising its overriding jurisdiction.
There was no stay on the order, was there? So has the assessment taken place?
I'm afraid I have no knowledge about that because obviously I'm not, speaking for Mother, am not included in any of that information.
In the father's skeleton that there's an issue raised about whether any information should be given about the process. But I do raise the question about whether this court should be told whether the assessment has taken place, and if it did, presumably it will have concluded now or around now.
Well, my lord, I accept that. I start from the position that I am in the dark about that. I fully recognise the decision in Axon and the cases that have followed, and that the issue of the confidentiality of the child's medical records is an issue which the court has to grapple. My answer to that, in fact, is, in this case, could be, it's not necessary that any medical information in relation to that assessment is disclosed to the mother, provided it is disclosed to the court and, if necessary, a confidentiality.
Well, I've put the question up, and Ms Foxwell may want to deal with it in time. But
Thank you.
Flag it up.
Now, again, I'm trying to outline the approach I'm going to adopt and then get on and adopt it, if that makes sense. I'm going to deal shortly with factual background using the judgment, paragraphs 1 to 13, and taking you to one or two references, but really the facts are neatly summarised by the judge. I'm then going to take you to Cass on the basis that I submit it is relevant to the court's assessment of the proper approach in law to this jurisdiction. Then I'm going to mention briefly the NHS developments which are flagged up in the skeleton and give you the references. And then I'm going to deal with the grounds of appeal as per the skeleton, but really focusing on, I think, a handful of cases, Re W, A, B and C, D, and I'll touch on the Australian case. But that's just to give you a flavour of where I'm going. In terms of the factual background and references, the judgment is at our bundle, begins at our bundle at CB22, so CB is my shorthand for core bundle. And may I just take this relatively speedily because I'm aware you'll obviously have read it. But simply to note, paragraph 3, the parents separated 10 years ago. Also paragraph 3, Hugh first informed parents transgender in or around October. There may be some dispute about that, but around the end of 2020, at which time Hugh was around the age of 12. I'm not going to give date of birth or anything like that. You'll read that, but around the age of 12. At paragraph 4, mother, acting as a litigant in person, made the prohibited steps order on the 15th of August 2022, and you can see the terms in which she set out her concerns, and I'm not going to read them out, at C100, on a C100, and that's at our CB 576 to 581. I'm not going to take you to that now, but I would ask you, if you have the opportunity to just cast your eyes over the concerns that she was raising about her child. There was an autism assessment carried out, and this is referred to in paragraph 4 of the judgment, which showed certain traits. The mother, in the course of that assessment, and if you look at it, you'll see that information is taken from mother and father and an assessment of the child. But if I may, I'm not going to turn this up just for time reasons, but the reference is at CB Core Bundle 44. The mother reported a laser focus on trying to get hormones. And what I will say is that that is of a piece with the nature of the condition. And may I just take an aside at this point to show you the definition of gender incongruence, which that is the classification decision, so the definition within which is in one of the appendices to the CAS review. It is within our core bundle at 557. And I'm particularly looking at the ICD-11, International Classification of Diseases. May I just check I've got the right reference?
Which page?
Page 557, left-hand column.
Yep.
Gender incongruence of adolescence and adulthood is characterized by a marked persistent incongruence between an individual's experienced gender and the assigned sex, which often leads to a desire to transition in order to live and be accepted as a person of the experienced gender through hormonal treatment, surgery, or other healthcare services to make the individual's body align as much as desired and to the extent possible with the experienced gender. It can't be assigned prior to the onset of puberty. The reason I am referring you to that is because it is a feature of the condition, unusually for medicine. It's a feature of condition. That is, part of it is the desire to take medicines, hormone treatment, in order to align with the wished for gender. And unusually, again I say, the treatment which is being sought here is to say you want gender affirming hormones. The treatment for that is to give you them. That's simplistic, but it is an important feature of understanding it. Because when we come to look at CAS, as I hope
very simplistic, I may suggest, that the overall description is of an all-consuming, my word, desire to transition in order to live and be accepted in the experienced gender. Part of that, agreed, is to have the hormones. It's not a definition of the condition is the desire to have the medication, and the treatment is to give you the medication. So if you intended to say that, I think that's unduly narrow.
I am properly corrected. I didn't intend to say that, but I was trying to observe that a feature of achieving the goal is treatment through medication.
To deliver what's asked for.
Thank you. There was then a local, I'm reading the facts from I think we're around paragraph 4 of the judgment. There was a local authority assessment which identified some dialogue amongst Q's peers regarding a relationship with the father's partner's child. No particular point turns on that. But at CB80, just for your note, core bundle page 80, in the report at 40, aged around 14 and a half at the time of this assessment, the child was adamant that they wish to undergo treatment. He does wish to have surgery. He can take out a loan to have surgery rather than a university loan, was one of the things he was saying to the local authority at the time of that assessment, aged around 14 and a half. At paragraph 5, there is a GP, and it's in the bundle, who gives a diagnosis of gender dysphoria, although we don't really think there's much detail behind that, but it gives certainly a gender dysphoria in a letter, and says there's no clinical evidence that he has any other mental disorder. Paragraph 5 also refers to the precipitative steps order made in respect of private treatment, and that was at around that time, not least because there was a concern about going online and accessing the services of a provider called Gender GP, which is not really what this case is about anymore. I don't want to spend too long on that, other than to say that Gender GP is based outside the UK and is not regulated within the UK.
And I have been critical of Gender GP in another judgment.
Indeed, Mark. There's a paragraph 8, there's reference to the judge's meeting with Q, and a note of that meeting is in your bundle at page 95 to 96. Again, I'm not going to turn that up, but that's really for your note. At paragraph 9, the court refers to permission being instructed to a child and adolescent psychologist and an endocrinologist. As it turns out, in the event, the endocrinologist didn't respond, and for reasons which are set out in the judgment, partly because Q refused, but also partly because Q had seen details about the psychiatrist, didn't want to be assessed by that person. Paragraph 10 refers to the guardian's reports, and there are at least 2 in your bundle. For my part, I simply make these points, that while it is right that within those reports the guardian makes the point that although mother's concerns are founded in well-meaning and genuine concerns, the guardian does say continuing resistance to her child embarking on a medical transition journey is causing damage to Q, and that was one of the points that's been reflected in Lady Justice King's grant of permission to appeal, the predilection of the child for the treatment and the period it's gone on to, and the strong desire to access it. But my argument is that actually that guardian report doesn't seek in any meaningful way to weigh the short-term harm against the long-term risks of irreversible harm. It doesn't refer, for example, to the fact that within the NHS there has been a pause on all new under-18 referrals for gender-affirming hormones for the reasons set out in the CAS review. And one of the reasons for that, and as explained in CAS, and I'll take you to the relevant passage, but I'll give you the reference, it's paragraph 16.3 of the CAS report.
Paragraph
16.23.
16.3.
16.23 of the report, and I'll give you the page reference in a moment. The point expressed there is that for those who are in late adolescence and not on puberty blockers, so essentially this case, managing any mental health problems, and I pause there simply to note the concerns raised in the local authority assessment, ensuring participation in education and work, supporting social transition and organising fertility preservation if required, are more pressing issues than commencing masculinising/feminising hormones. The thrust of CAS, the reason behind the pause, is that there should be wider exploration of underlying issues before commencing hormones, and extreme caution should be exercised and compelling rationale be given by any doctor who does that. The Guardian's report says nothing about the likely and foreseeable consequences of the journey in terms of irreversible consequences such as loss of fertility, potential loss of sexual function, all those things which form part of the proper dialogue that has to take place. The lifelong journey on a lifelong journey of hormone treatment. Now, it's also noted that, and the Guardian recognises, there is no assessment by a child and adolescent psychiatrist, and that remained a gap in the evidence. And Q, for reasons which the judge clearly understood and accepted, was resistant to being assessed other than in the context of a treatment pathway. But that treatment pathway was aimed at with Gender Plus and would have necessarily involved such an assessment. The thrust of what the Guardian was saying was that once the child Q reached 16, the court would have no more role to play, saying, I'll give you an example, it's at paragraph 63, I think it's page 123 of the bundle, because of the right to consent to his own medical treatment, or because the presumption of capacity under the Mental Capacity Act applied. And the final point about the Guardian's report is it uses phrases such as mature beyond his years in relation to the child Q. Now, the appellant's approach to that is to say, we don't for a moment suggest that Q is not intelligent, articulate, and has researched gender treatment to a high degree. All of that is almost certainly true. But there's a great difference between highly functioning or highly intelligent decision-making in respect to a range of matters, whether it be doing your A-levels or whatever, and taking a decision with respect to taking hormone treatment, which is a part of the condition that you're suffering. And an analogy I draw is between the anorexia type case, where high-functioning individuals suffering from anorexia, well able to get A stars in their A-levels, at the same time are unable to make the decision in a discrete aspect of their decision-making, namely whether to take food, because of their perception or misperception of their body and their shame.
The difference surely is that in the anorexia cases, almost always, probably always, they lack capacity. And that's the basis upon which the treatment is ordered, contrary to their wishes. And it's not suggested here that Q lacks capacity.
Well, may I return to that point, because I think my argument is this. Capacity cannot be judged in a vacuum. Fairly trite point. What the Guardian says about capacity, articulate, intelligent, I accept.
I was thinking Mental Capacity Act. I wasn't thinking about the Guardian's assessment of the boy.
But come the time of assessment of the individual by Gender Plus, there is at least the possibility, is my argument, that on a proper assessment, the use, retain, weigh assessment is felt not to be satisfied in relation to the taking of hormones.
So you're going to have to say that again. There's at least the possibility that...
that I've used a shorthand of use, retain, weigh because...
So use...
Use the information, retain it, and weigh it up.
Oh, so use, retain, and
Section
weigh.
3 of the Mental Capacity Act.
I apologise. I use a shorthand unhelpfully. What I'm trying to express is that within the Mental Capacity Act, in order to ascertain whether a person lacks capacity, it has to be demonstrated that the person cannot use, retain, or weigh the information properly, and that lack of ability to use, retain, and weigh is attributable to some underlying mental disorder of mind.
Yeah. Okay.
Well, if I write down
Sorry,
attributable to an underlying condition, mental health condition,
Yes.
is that right?
Well, it would be.
Not a mental health.
Well,
No,
Yeah.
I'm going to stop. I'm going to
It's a
stop. It'd be easy
disorder
to
of-
go. It's a disorder. It's better to use the terms of the act. I mean, I will return to that
We
in
look
the
at
cases in due course. But
I don't think we need to. I don't think we need to go.
No, I don't.
Well, we need
I
to
think
go.
you headed up a cul-de-sac with our encouragement.
Sorry, my fault.
But
I just did think it was important for us to be conscious of the fact that in the anorexia cases, there's usually been found to be a lack of capacity on the part of the young person.
absolutely
That's not
right.
this case.
Absolutely right. And all I'm trying to say is that there is at
If
least.
he's assessed, someone might decide that he does lack capacity and that because of diagnostic tests will be satisfied because of his gender incongruence. Yeah,
No, lady, that's the only point I sought to make. Thank you.
I've got that.
So just for the slow members of the court also to get there, you made the submission. Come the time of the assessment, there is at least the possibility that within the Mental Capacity Act 2005, it could be said that he would be a person who could not use, retain and weigh the material relating to gender dysphoria treatment because
of an underlying.
Because of his underlying dysphoria.
because of the dysphoria.
Yeah.
Right.
That's the argument. And I don't, if I can avoid going to the authorities to make the point, I will. But one of the cases in our bundle, I think JB, explains how you have to formulate the matter in respect of which the person has capacity. And we saw that a bit in the
I mean,
Bell.
is that in your skeleton that it's being now said, which I think was not said below, that come the assessment anyway, there would be a real possibility of a lack of capacity for the reasons you're now giving?
It is.
Is that there?
It's one sentence.
It is, but it is in the skeleton.
Okay, could you just tell me where the sentence is? So that again,
Beginning of ground 2.
Right.
Monday. It's in a rolled up in a sentence. It's not.
I didn't see it in ground.
No, it's not in ground. It is in ground. It's on page 593 in the recitation of ground 2 between paragraph 14 and 15. The little Roman 2. Mother disputed the propriety of the treatment, the diagnosis, and Q's capacity to give informed consent. And that, I think, is the only reference. And the judgment doesn't, in the course of her judgment, the judge, paragraph 14, records the issues as they were before her, and she doesn't recall that there was an issue of capacity.
But I should make clear, I put that on the basis of there was at least the possibility. My argument proceeds even if it is assumed against me that on all bases the capacity test would have been satisfied and capacity would never have been rebutted at any future assessment. Because the prime thrust of my case is that the override that exists, the jurisdiction to override, includes to override a capacitous decision for medical treatment. But I raise the point that, and this is to pick up on the prematurity of dismissal of the proceedings point, that there was at least the possibility that in assessing whether, having formulated the matter appropriately, engaging in hormone treatment, and identifying the salient features which a person would have to understand, use and weigh to make that decision, that an outcome could be that this individual didn't because of the underlying condition.
I mean, I get this point now. Thank you. But what I don't get is the submission that you made earlier, which is that the override of Section 8, effectively, Section 8 consent, can take place either where there is a serious threat to life or when a serious decision is being taken in the person's life. It seems to me that what you're saying is now something different, that this override that you say the judge should have adjourned the proceedings for is because of a genuine likelihood, possibility, serious possibility, I'm not sure what, doesn't matter really how high you put it, it's got to be tangible, a tangible risk that this person will, at the assessment stage, lack the capacity to make this decision for the reasons you've given us.
Yes, there are 2 points. Sorry, they're separate points. There's no requirement to... Sorry, can I try and explain it as simple as I...
Make it as simple as you can.
Sorry. Apologize. What I'm trying to express is this point, that if at assessment a court determined that Hugh lacked capacity, or that the presumption of capacity under the Capacity Act was rebutted because of use and way, you don't need override because you're into the best interest decision making.
Yes, of course.
That's argument A. There was a real possibility of that. Argument B is, even if the judge was right to say, totally unrealistic, that there would ever be found to lack capacity on assessment of salient factors, my argument is there is still the court's overriding jurisdiction, and because of the highly controversial nature of the treatment, it was an issue that the court should have remained seized of in order to, police is perhaps the wrong word, ensure that that which was being done was objectively in the best interest of Q.
Can I just pick up A? Because it feels like A, in a way, morphs into the adjournment issue, because I think what you are saying globally is that any proper assessment of a young person with this condition, preparatory to a consideration of treatment, will inevitably involve a capacity assessment. I mean, it just will. Doesn't even necessarily need a psychiatrist, because capacity assessments are done up and down the country by social workers and so on and so forth. And I think your argument is going in the direction of saying, given the nature of the treatment, reinforced by what Cass says about it, and the young person's age and so on, and their very condition, the judge was therefore, in applying the welfare aspect of this case, wrong to have refused the adjournment, because the outcome should have been of the assessment in relation to the child's proper ability to consent, by reference to Section 8, should have been ascertained before the proceedings were concluded.
That is far more concise. That is my case, and as concisely, much more concisely than I've been able to articulate it. But that is what that is.
I'm slightly taking you out of course, because my Lord the Master of the Rolls is rightly concentrating on the legal aspects, but it seemed to me that your A was actually really more of your welfare adjournment analysis.
That is correct.
And your B, you say police, you're in making that submission, having regard to the fact this is jolly tricky stuff, and it's important for the clinician who's determining whether or not an individual has capacity to consent to go through the process of explaining the trickiness of what's involved to the young person, including the potential risks, ensuring that they've understood that and they can use and retain and weigh the downside of the proposed treatment, as well as the, as you say, laser focus on I want it and I want it now, and that's a sophisticated exercise in the assessment of capacity. And I think what you're saying in your B is that the court should have held on to the case to see how that played itself out and to audit, rather than police, what the clinic did, and if they decided that he had capacity, whether they had conducted that exercise correctly. And part of that point is your separate point about fairness, that it, given the mother's very, very clear opposition, it was unfair to cut her out of that further process of allowing it to be played out, which she was agreeing to, and seeing what comes out of that, and having her say as to whether that was a proper exercise. Is that's your point?
My Lord, again, extremely concisely put, that is precisely the legal argument on to leave aside the wider arguments about special category and so on, but that is exactly right. Sorry, my Lord.
Now I've got an original question, haven't you?
My Lord, may I note? Now, I'm still in the judgment. I've got to keep an eye on the time, but the may I take you to paragraph 12 of the judge's judgment, just to note these matters and give you references. Gender Plus gained CQC registration. This is in paragraph 12 of the judgment. Although I note as an aside, although I don't take it any particular direction, that registration is currently subject to judicial review, permission having been granted by Mrs Justice Foxton on grounds of irrationality and no sufficient evidential basis for...
Have we got his order?
We have supplemental bundle 223 is my note. Yes, it begins at 223 and continues to 226.
Yes.
My Lord, the second point arising from paragraph 12 of factual context is the evidence was produced as to Gender Plus's methodology, and we have that in our bundle. By methodology, I mean how they go about assessing 6-month period and so on. And that is at core bundle 99 to 101, essentially 6 months of assessment followed by a referral to a hormone clinic, in which it's stated working in accordance with what's called the WPATH standards. And if I may be permitted an aside, what CAS has to say about them, and I'll show you in a moment, is that they reference being Power 47 of CAS, our reference, core bundle to 109, in inverted commas, lack developmental rigour. They are not compliant, the letter acknowledges, with some aspects of what was then the interim, and is now the interim service specification. We say, crucially, the absence of a second opinion from an independent body. And if you ask me, well, why are you saying that's crucial? Because this is a private sector provision. Within the NHS, there is a requirement, and I'll show you where it is, that there is a review by an independent body of the decision to commence hormones. And there is no such safety check in the private sector, and acknowledged, is clearly acknowledged to be the case. The judge goes on to note that the CAS review is published, and of course that Q has turned 16. In terms of the developments, may I just take you very briefly to these? The first, and they're referenced in the skeleton. They're in my skeleton at paragraph 8. There are three important developments I note. One is the second opinion point I've just made. The reference for that is 142 of the supplemental bundle. And the place that you will find that on 142, may I turn that up? I don't want to spend too long on it, but may I turn this up? 142 of the supplemental.
What is 142?
We are within a document which is called Clinical Commissioning Policy, issued on the 21st of March 2024. So short.
That's page 139.
Thank you. And it makes some descriptions about the, and then it produces a table of what are called eligibility and readiness criteria for hormone treatment, and that table is at 141. And may I just note three of the boxes. The first, at the bottom of page 141, the eligibility and readiness criteria include that the impact on the individual's fertility has been discussed with them. They understand that the treatment will affect their fertility, and that if required by the individual, a request is made to the GP to refer on to licensed fertility experts for discussions on egg sperm retrieval and storage. So it's a very important part of the, whether it should commence at all, that these informed discussions can take place about fertility. I don't want to go on too much from the side, but you'll remember in the Bell case, one of the issues which was discussed and certainly argued was the difficulty that an individual of, say, 12, 14, 16 can have of understanding the consequence. And if I may be permitted just to say, within the evidence in the Bell case, there were individuals who were a little bit older but had given statements, and the thread that ran through was that those decisions, they often said when young, I don't want to have children, I'll just adopt. That was a phrase that one saw in the Bell evidence. And that's why these fertility discussions are actually finely balanced. The difficult decisions for a 16-year-old to have, and why it comes back to the point I was making about this fine decision and the need for that to be carefully weighed out. The second box at 142 is left-hand box, top of the page, that the individual is able to give informed consent and has cognitive and emotional maturity. That is, they must be given all of the information about what the treatment involves, including benefits, risks, etc., and whether there are reasonable alternative treatments and what will happen if the treatment does not go ahead. Now you might say, well, that's just standard treatment, but it's really important because part of our case articulation, the skeleton, is that in order for treatment commence, there must not only be the ability to understand and weigh information, but there must be the discharge by the doctor of the duty to make sure the alternatives are properly explored and explained. And I don't need to give examples, but one can see why that's so important in the context of the Cass review, essentially saying it really is important that alternatives are explored rather than necessarily jumping into lifelong commitment, potentially, to hormone treatment. And the last point on 142 is the left-hand box at the bottom of the box table, the CYP, that's Children and Young Persons, Gender Service National MDT, that includes clinicians not directly involved in the formation of the individual's care plan, agrees on the suitability of the individual receiving gender-affirming hormones based on the consideration of these eligibility and readiness criteria. So that's the second opinion.
It's quite interesting, isn't it, that when we look at the other column, the reasons for the criterion, is to ensure the individual understands the limitations of the clinical evidence. It's not just to check out that they've actually consented, but it's actually that they have a real understanding of the parameters and limitations of the treatment and
exactly, and that is
the research.
And that's based in part, I'll try and show you speedily within the CAS review, concerns such as later detransition, later wish to detransition, discovering at a later stage that, and regretting, sometimes they're called regressors, who look back, and you've got to understand that some of these changes are permanent, and are permanent very quickly. Dropping of the voice, for example. It happens, and once happened, it doesn't really, that is irreversible. I'm not saying, I'm using that as an example, aside from fertility, but that's on the point.
Just while we've got these pages open, the number of boxes and the detail within the boxes underlines the jolly tricky decision point that I was putting to you. And then the other point to you've probably seen at the very top of the boxes, inclusion criteria, patients must meet all, in bold and in capitals, of these criteria.
Indeed, my Lord. I'm very grateful for that additional observation, which is absolutely right. And the emphasis on the all is to show it's a narrow gate, is my way of phrasing the effect of those boxes. I've mentioned this by reference to paragraph of the skeleton, the second opinion.
So just before we leave this NHS document, does this document apply to a private clinic?
No.
It does not apply?
No.
And what is the role of the CQC in regulating a private clinic by reference to NHS standards?
Well, without recourse to I think it's the Health and Social Care Act, which sets out the responsibility of the CQC.
Sorry, just don't drop your voice too much.
Sorry.
Health and Social Care Act does what?
I understand that the CQC's powers and duties, this is off the top of my head without being able to produce the statute before you, has powers with respect to the regulation of hospitals and centres which provide care. The important thing to note, and you'll pick it up in the evidence, is it's the endocrinology bit of Gender Plus that is CQC regulated, not the initial assessment
part of it. So it's the equivalent, when we go back to Bell, the equivalent of Tavistock is not subject to control.
Exactly.
Whereas the referral, Gibbs,
Yeah.
But the equivalent of Leeds is.
Exactly. And the
Sorry, just while we're interrupting, the date of this document is March 2024, and Gender Plus, I'm presuming, was already registered, before that.
It was very short.
If it did apply, it wouldn't have been in existence anyway, in those terms.
The CQC regulating a private provider make sure it abides by appropriate. I haven't got the legislation. If it's necessary, we'll have to revert to this.
But this is a provider you're talking about of treatment.
Yes.
So this is the equivalent of my lady's Leeds in Bell,
Yeah.
not Gids or Tavistock,
Correct.
which assessed.
Correct.
So is it the case that the private assessment of Gender Plus is not regulated?
Correct. Well, it's not. It is regulated in the sense that the persons providing the assessment have regulators.
regulation, but they don't have clinic regulation.
No, correct.
That's really the case.
That is the case.
And do you say, I mean, I know it's part of your case that a private clinic should not be effectively providing this generally in the state of uncertainty demonstrated by CAS, but that seems to me to be a bit beyond our pay grade here. Mr. Justice Foxton may have given you permission to judicially review that, but that's not what we can decide.
No, it's not. It's not. And I'm not asking you to decide it, but what I am asking you to is acknowledge the following rather broad submissions. Firstly, that the CQC doesn't regulate the assessment bit of Gender Plus.
Well, I get that, yes.
Point one. The CQC does regulate the endocrine provision, but the CQC does not require the endocrine provision bit of Gender Plus to be compliant with NHS requirements.
The judgment dated the 8th of May was therefore some months before the very critical review in October of the operational effectiveness of the Care Quality Commission and particularly its assessment framework.
Correct. It
And
was before
particularly
that.
Assessment framework, you know, how
Right.
they decide to give someone.
That is correct. But if I may anecdotally say, the CQC regulated Leeds and the GMC regulated the Tavistock clinicians for the whole period of the development of the gender treatment programme, which was developed at Tavistock, which is ultimately recognised by Cass, my phrase, to have gone off the tracks. And I'll show you her phrase in a moment. And the point I make is you cannot, or the court in its protective function, should at least have regard to the fact that there are real concerns about the effectiveness of both the CQC regulation and the effectiveness of GMC regulation of the individuals in order to protect children in this very special area of gender treatment. And that, we say, is the story of Cat.
But it puts the court in a somewhat difficult position, but it feeds, does it, into your special category point?
My lord, yes.
So you say there is such uncertainty about this that we should depart from what was said in Bell because we have new evidence in the shape and form of Cass and perhaps in the shape and form of the commissioning, whatever the report was my lady referred to in October. And we should say, you say, that the regulatory framework is so dubious, doubtful, or anyway fresh, and has been shown to be flawed in the past, that it was inappropriate for the judge to exercise her discretion to release this case into the unknown, and she should have kept it, notwithstanding the palpable distress caused to Q, she should have, the better course was to look at it after the assessment.
My lord, that is my case. As you have just expressed.
And it does require us taking a different view from the view we took in Bell, but you say for good reason.
My lord, I say for good reason, and for two reasons I tried to articulate before, but if I can summarise, one is a distinguishing feature, as Bell is really concerned with puberty blockers, but I see that perhaps is not.
Well, it was, and indeed they're illegal now, as I understand it. So, or they were announced to be going to be permanently made.
Yeah. Well, I think my submission is that it is open to you to depart from that in the light of the factual developments which I've referred to.
I thought Bell was about puberty blockers with the knowledge that you proceeded always, nearly always,
exactly,
from puberty blockers to hormones.
Yeah. Exactly right. So I can't completely sort of brush Bell out, but I say that that its main focus was on puberty blockers. The subsequent developments. on one view, the Bell judgment says, leave it to the regulator, leave it to the doctors. Don't ask the court to intervene on this.
Yes, we did say that. I was there.
Sorry.
I mean, that's, but
I know that. Sorry.
what you're saying is, in the current level of uncertainty, we can't, the court can't properly,
Exactly.
because of the need for
that's my
supervision in the best interests of the child.
That is my argument.
And, I mean, the problem, if I can put it to you, is that where's the evidence that CQC is, I mean, my understanding, I have particular regard to the Guardian's skeleton argument, where I think Miss Munro goes through what was said to be uncontested facts in her skeleton, which I found very useful to have them collected together from the judgment. And when I read those, I thought, well, those are the uncontested facts that actually drive a coach and horses through the suggestion that there is dubious regulation and that these people will all go, that may go wrong. We could assume, for the purposes of this decision, that they were properly regulated, that doctors would do their job, and that, Gillick, if it were Gillick or post-16, we would be satisfied that proper consent was obtained and the capacity under decision would be made appropriate. You say no.
I say no.
You say no.
And I think you say, even if this court was against you as to whether there's actually a special category, that all the same features that you've articulated would go to whether there should have been an adjournment.
Indeed. Exactly right, my lady. That is my...
Well, I mean, the first question is whether the adjournment was right. I mean, we may not even get to a special category, but I suppose we need to override Bell, really. We need to at least...
engage with that argument. I'm inviting you to engage with the argument.
Well, we have to engage with the new evidence, as you say. I mean, it would be helpful to me, anyway, if you took us to the new evidence about the regulation of private clinics and CAS. What CAS
Well,
said.
I'm certainly going to say you to CAS. It's next on my list. I appreciate I've got slightly behind the clock, but can I... May I just finish with the last... I'd taken you to the service specification. We'd looked at that. May I take you to or give you the reference only, in fact, to the fact this is supplemental bundle 135 to 138. Puberty blockers not being available to children and young people, and only as part of research protocol.
Sorry, which page?
Supplemental bundle, page 135 to 138. First sentence, 12th of March 2024.
But that was the interim measure.
That was
which
the interim measure,
confirmed
and it's now
yesterday
been
by the
made.
government.
Sorry, I must have got it wrong. It was 135.
135 of supplemental.
Supplemental 135.
Yeah, thank you. That was 12th of March 24, confirmed yesterday.
And the third piece of development, post-Bell development, is the pause on under 18 referrals post-CAS, reference supplemental bundle 149. This is the end of 149 is the end of a letter of the 9th of April 2024, which begins on page supplemental bundle 147, and the sentence I'm particularly referring to is signed by John Stewart and Professor James Palm, is the third bullet point under the heading immediate actions. Defer offering, page 149, defer offering first appointments to patients until their 18th birthday as an immediate response to Dr. Cass's advice that extreme caution should be exercised before making a recommendation for gender-affirming hormones in young people under 18 years of age.
And was this document before the judge?
I have looked.
It dates.
She doesn't refer to it.
She doesn't refer to
No.
it.
But it's dated the 9th of April, and
It's
the
dated the
date
9th of
was
April.
the 17th.
I can't say to whether it was adverted to. It's not referred to in the judgment. I've looked to see reference to it in the underlying papers and I haven't found it. But it is a point I rely on as part of the factual matrix. My lords and your ladyship, may I try and deal with the CAS references I'd like you to look at next?
Yeah, I'm sorry, I'm struggling with this letter. This is a letter from the National Director of Special Commissioning, NHS England.
Correct.
In April, following CAS.
Following the CAS review.
And indicating the steps that are, all the steps, is it, that are to be taken. I'm sorry, CAS is the following day, but it's to draw attention to it. And there's going to be a review.
Yes.
And it sets out the immediate next steps. And the immediate next steps are then set out on the next page.
Yes. And it's the third bullet.
Yes, the third bullet, limited. Sorry, the third bullet on the following page.
The third bullet, defer offering first appointments to patients until their 18th birthday. So I read that if you're already in the system,
correct,
you carried on.
You carried on,
but
no new referrals for under 18s for gender affirming hormones.
Page 149, which is why I was confused. I've got it now.
And so if Q had been coming through the system at the time that he's coming through the private system, he would have been met with a complete no by the NHS until he's over 18.
Correct.
As a result of these interim actions.
Correct.
But the private treatment, and certainly the private assessment, is not illegal.
It is not illegal.
And there are people presumably being privately assessed and indeed privately treated under 18 now, are they, by this clinic?
Almost certainly are, yes.
As far as you know, yes. Right. Without court proceedings.
Without court proceedings, other than the judicial review that's been mentioned.
No, but I mean, you are saying, as I understand it, that every case ought to be subject to judicial supervision.
In the private sector, and certainly where there is a dispute.
I mean, I'm being frivolous now. It doesn't bother me, but I expect it bothers the president, because these cases, if there were, there would be presumably many cases in the family division.
Well,
would there not?
I mean,
if you
there
were
are not that many young people. It's not a small number, but it's not a large number. And your caveat is that certainly where there's parental dispute, and it's not a given, obviously there'll be a parental dispute. And so,
indeed, look, it's not for me to say whether it's manageable by the family division, because that's not my question. I
mean, I'm only being concerned for my
that's
law.
the way the law should go. That's the way the law should go, and the resources have to follow. But it's not an insignificant matter, but it's not a very large number.
But you say only when there's parental dispute.
May I correct you? I don't say only. I say certainly where there's parental dispute.
So no much.
Well, I mean, the consequence of your argument, if it's correct, is that the court should look at it even where there is not parental dispute.
Yes, that is the consequence of my argument.
Yes.
But I allow a filter, similarly to in the Australian situation, where there is a dispute. Because the way it emerged, if you see, Mrs Justice Leven in A, B and C, D analyses two Australian cases, Kelvin, I think, and Jamie, and comes to the conclusion that where parents agree for stage 2 treatment, Kelvin's decision, it doesn't need to come to court in Australia. that's recognised by Mrs Justice Leaven, looking at a case where the parents were coming to court agreeing with the treatment and the clinicians were in agreement with the treatment. My case is that it should be all cases, not just those where there is a dispute, because of the underlying nature of the treatment. But I say in the alternative that if that's too wide, then certainly where there is a dispute.
But even, certainly where there is dispute.
And so, I mean, looking at many of these a much less serious matter, we have a pattern for this, don't we? Because if you want to change a child's surname, if everybody agrees, then nobody comes to court. But if there's a live with order and they don't agree, then they have to come to court because it's the Article 8 rights of the parents and their exercise of parental responsibility that has to be respected and considered before an important decision is made in respect of their child. So is that far less serious, obviously?
Far less serious,
but is that the sort of same?
It's a sort of framework under which I say it could operate. Yes.
Yeah, I see.
May I try and do CAS not too fast, but in a way that is.
I'm sorry, I keep interrupting.
In a way that I hope is helpful to the court. I'll just say this about CAS before I go about the judgment. At paragraph 58 of the judgment, the judge says, really in relation to CAS generally, it would not be right for me to comment on all of this. Is a sort of throwaway. Not criticising the judge particularly, but I say far more close assessment of what CAS says was required before adjourning the proceedings. Sorry, not adjourning, rather dismissing the proceedings. And my argument is, this is the prelude to what I'm going to tell you about CAS, is that the relevance of CAS to the correct approach is because we're dealing with private treatment, irreversible, highly controversial, and as identified in the grant of permission, may not be able to be provided in some of the circumstances recognised in the CAS review. So if I could pick up CAS and begin at the beginning at page 193 of our core bundle. And simply just to say 193, first paragraph, left-hand column, fifth line down, what's the review about? It's about what the healthcare approach should be and how best to help growing number of children. Page 19, if this way of approaching it is irritating the court, please say, because I don't want to irritate the court, but what I propose to do is show you the passages.
No, it's helpful.
Page 194, right-hand column.
We're not so oversensitive, Mr. Hand, that we get irritated by people referring us to documents. In fact, particularly not core documents in the case.
Yeah.
So but please take your time.
Normally in this court it's obvious when the court is irritated. No need to invite us.
Thank you very much.
194.
194, right-hand column. Third paragraph. This is an area of remarkably weak evidence, and yet results of studies are exaggerated or misrepresented by people on all sides of the debate. The reality is we have no good evidence on the long-term outcomes. Also, 194, the reference to bottom of the page, last 5 lines, some practitioners abandon normal clinical approaches to holistic assessment, which has meant that a group of young people have been exceptionalised compared to other young people with similar complex presentations. That's a reference to the development of treatment under the Dutch protocol and going beyond the Dutch protocol at the Tavistock. Page 195, the author turns her attention to the young people affected in particular and explains why she's saying that puberty blockers should be in research only. At page 202, if I may, we're now into that part of the report which is called Summary and Recommendations. Right-hand column, three bullet points up from the bottom, under the internal paragraph 13. While some young people may feel an urgency to transition, young adults looking back at their younger selves would often advise slowing down. Next, for some, the best outcome will be transition, where others may resolve their distress in other ways. Some may transition and then detransition or experience regret. Page 205, please, there's a graph. And just to understand that the yellow colour is natal females, and this is described as an exponential increase in the number of cases coming through.
We had that evidence in Bell, I think.
We did. 206.
It's quite, I'm not at all questioning what's there, but it's now quite old, isn't it? We don't know what
We don't know what
happened after 2016.
I'm afraid I can't help on that. 206. Subparagraph 23, right-hand column of 206 at the top of the page. The adoption of a treatment with uncertain benefits without further scrutiny is a significant departure from established practice. This is in combination with the long delay in publication of the results of the study has had significant consequences in terms of patient expectations of intended benefits and demand for treatment. That was a reflection on the, you remember in the Bell case, the publication of the study, certainly in first instance, it was ordered effectively by Lord Justice Lewis, as he now is. If I could move on to 20, well, may I just pause on 207 and just say about this significant departure from established practice, because that is a feature, and while I don't draw a direct analogy, and I don't really want to spend time going there to the re-de-sterilisation case, Dame Hilary Heilbronn's decision, because that's about different things. What happened is not so different, something that really doctors are looking at aghast and saying, that's just not normal medical practice. Why did that happen? Well, that was the sort of thing that happened in re-de-sterilisation, where a doctor was willing to give, I think, a hysterectomy to a young girl, and fortunately somebody stepped in and said, that's just not appropriate to make that sort of decision for an 11-year-old girl at this time, and the court stopped it. The 207, there's a note about children and young people being on a developmental trajectory. This is subparagraph 36 in the bottom right-hand corner of 207. Just for your note, that is then elaborated on at paragraph 6.35 to 6.38 of the CAS review, which is to be found at RCB 283, and it's the point of the maturation of the brain. And in terms of its relevance, if I said I wasn't going to turn up, but if I may just very briefly turn up simply to say, a significant point that comes out of the evidence, and it's at, I think I'll give you page 283, 6.35 to 6.3, so in the right-hand column, in particular 6.36, it used to be thought that brain maturation finished in adolescence, but it's now understood that this remodelling continues into the mid-20s as different parts become more interconnected, doesn't proceed evenly, and there's points about risk-taking and so on. And the 6.38, the future-orientated prefrontal cortex matures later with development continuing into an individual's 20s, and as illustrated in figure 19, is concerned with executive functions such as complex decision making. I'm not giving a sort of lecture on brain development here, but the point, it reinforces the point about the jolly difficult issue in determining the choice going forwards for a 16-year-old looking ahead to risks such as fertility and so on. Briefly, if I could go back to page 208, subparagraph 40.
So this point about brain maturation, does it go to capacity to consent, or does it go to the possible adverse consequences of the treatment? That you have the treatment too early and it in some way pauses or accelerates or changes your brain maturation? Was it both?
Well, I think it may go to both. There was some evidence about the effects of puberty blockers actually affecting the brain development. Some evidence.
That's certainly puberty block.
Puberty block.
Evidence about puberty.
There's an unknown about what it's like to go through puberty with under hormone treatment, and whether that has consequential effect. I mean, I'm not trying to explain it. I'm not explaining very well. What I'm trying to say is
I'm just trying to understand where this point takes us in terms of what we've got to decide.
I think only that it reinforces the jolly difficult decision point, because there's at least a concern that making these kinds of future prediction.
Well, it may go to the capacity to take
It does.
this decision,
Yeah.
because it actually says, I mean, I'd not read this before, but it actually says that your future, your ability to understand future orientation and therefore, I assume, risks,
Yes.
is developing into the 20s.
Correct.
Which is something certainly I didn't know. And so, yeah, I mean, it may go to various aspects of your argument.
It goes to risks, but it also goes back to your way and understand, back to your 12-year-old understanding about fertility or a 15-year-old understanding about.
And then also the possibility of regret.
Yeah.
You have the treatment, but then your brain matures some more and you see things, you're able to see things in a slightly different way.
But exactly the point I'm making. So I do rely on that. It could be said also, I think, that when one looks at something like Section 8 of the Family Law Reform Act passed following the Leahy Committee decision, exactly the point that Master Rolls was just indicating, not being aware of that. This is new information, not new information to this court. I mean, this is scientific information, but it's new in the sense that it informs how the brain actually develops in making certain types of decisions. And black and white judgments about 16 being a particular age for medical treatment as a blanket position.
Yes, well, we're seeing it in the review of how juveniles are being sentenced in the criminal courts at the moment for that very reason, because of the recognition of this research.
Exactly, and that indeed was a point made below, I think, by to the judge by reference to the Sentencing Council guidelines.
I mean, you will show us where Cass says anything about the point you made earlier, which I must say it seemed to me important, that the condition itself leads to a strong wish to be treated.
Well, I think the passage I particularly wanted to refer to was the definition of the condition.
Yes.
Which is an annex to CAS.
Which is in the annex to CAS.
Yeah, which page was it?
It was it's at page 557.
Right.
Left-hand column, it's called the ICD, that's short for International Classification of Diseases. I'm afraid I don't know what HA stands for, but HA6.
Appendix 10.
Yeah.
Yeah.
ICD 11HA60. Perhaps we could be told what that is.
Well, the ICD is a publication of the International Classification of Diseases. I think I'll have to check who it's in fact published by, but my understanding is it's a consensus body.
It's an American.
It is.
World Health Organization.
Well done.
Thank you.
But just while we've gone back to this, you took us to the wording under gender incongruence, where the point is particularly strongly made. But in Q's case, I thought that the understanding, certainly the GP for what it's worth, had diagnosed gender dysphoria. And gender dysphoria, if you're looking on its page 556, includes a longer list of characteristics, but on the right-hand column, it's, I think, the penultimate bullet, a strong desire to be treated. Oh, no, no.
To be treated as the other gender.
As the other, there's one about treatment, I think. When we were looking at it earlier, I saw it, now I can't. But I wondered why you'd taken us to gender incongruence.
Because my understanding is the preferred language now is gender incongruence rather than dysphoria.
Right.
But I'm equally happy to use the gender dysphoria in adolescence. That's a DSM 5TR. Again, I'm slightly thrown by the acronym, but the DSM criteria, or Diagnostic Statistical Manual, I think is what that stands for. DSM 5 is the version.
Yeah.
Sorry, just say it again. DSM is what?
DSM is the Diagnostic Statistical Manual. That's my... It's the American Psychiatric Association.
And for my Lord's benefit, it's a big book with every single possible diagnosable mental health condition categorized in the way that this is here. It's a way of standardizing practitioners' approach.
And you may find that a psychiatrist might diagnose and say gender dysphoria / gender incongruence, DSM 5TR, comma, ICD 1011, HA60. What you might is the sort of phrase you might find in a report.
Well, you get the use of both in all sorts of psychiatric reports. Personality disorder would be an example where you very regularly get both references.
Yeah, exactly.
And just to pick up from my lord, in that gender dysphoria list of bullet points in adolescence, there are a number of strong desires, and all of them would themselves really lead to a strong desire to be treated in order to deal with the desire to, for example, to be treated as your desired gender, a desire to not have the physical characteristics of your original gender, and so on.
Entirely right.
And so you would say that this is all, both in under dysphoria and also incongruence, is supportive of that point.
I certainly do.
I mean, there must be some reference to Annex 10 in the body of the report. If somebody could find that, it'd be great.
May I try and find that? But may I continue for the
Yes,
moment? Maybe
of course.
my junior could look at
Thanks,
that.
then,
Necessary Bordeaux lunch. I had got as far as about 200 and...
We've been on 283, and you took us to the because of the brain maturation.
Yes,
We've been on 206 before that.
Thank you. May I come back to page 208?
The answer to my question is at 1066 and 1067 at page 328. It's the answer to my own question.
308.
328.
328. 10
Which refers to Appendix 10 and also explains the acronyms, the American Psychiatric Association, most widely used framework for diagnosing gender dysphoria, see Appendix 10, blah.
I ought to have taken you to that first, so I apologise. Thank you.
All right.
If I may go back to internal page number 208, under the, we're still in summary and recommendations, but paragraph 45, the findings raise questions about the quality of currently available guidelines. Most guidelines have not followed the international standards for guideline development. And because of this, the research team could only recommend two guidelines for practice. The Finnish guideline, published in 2020, and the Swedish guideline, published in 2020. And may I jump forward just to show you that at page 363, we learn that. So I must make sure I've got the right page. Yes, it's 15.8 to 15.9 at 363 is the right-hand column. Only the Swedish and Finnish guidelines recommend that hormone treatment is given under a research framework or in exceptional circumstances. And then 1510, the majority of guidelines recommend providing information on the impact of hormones, etc., etc. And then 1511, the Swedish and WPATH mention the need for support. The only point I seek to derive is that the guidelines which pass the University of York threshold for guideline development has got the tick on the sort of quality control were Sweden and Finland, both of which are either exceptional or only in research. As to the WPATH itself, which is the guidelines that are followed by Gender Plus, the CAS report at 209, paragraph 47, that's in the left-hand column.
So page again?
Page 209.
Yeah.
Left-hand column, the World Professional Association of Transgender Care, WPATH, has been highly influential. Then 48 earlier versions are said, and at 47, although its last words of internal 47, left-hand column, although its guidelines were found by the University of York appraisal process to lack developmental rigour. Cass then goes on to say at 209 about the lack of consensus in relation to the purpose of the assessment process, and that's at paragraph 51, bottom of the page. The final words, the most striking problem is the lack of any consensus on the purpose of the assessment process. So even the Gender Plus assessment process, which is to be done, or at the time the hearing was to be done, Cass is really underlining there that it's not even a consensus of approach as how that ought to be done.
Or the purpose of it. It's the lack of consensus as to the purpose.
As to the purpose of it.
Which is odd.
Which is odd.
I would think it would be clear what the purpose was.
Well, you'd have thought the purpose was to establish whether further treatment, or what kind of further treatment, if any, was appropriate. And that could be treatment with drugs or hormones, but it could also be treatment with counselling, with lots of other things.
Exactly.
Presumably.
And the reason she refers to lack of consensus, because there are some who think you should really explore all those options before going down the medication line. And there are others who think, well, why wait? Get on with the gender hormones. There's not a consensus as to the approach.
We see recommendation 1 in the big box beside it, which makes the jolly difficult decision point.
Indeed. Yeah. Thank you. 213, paragraph 80, right-hand column. This is picking up on some of the Bell time to think. Rationale for the use of puberty blockers was that this would buy time to think by delaying the onset of puberty and also improve ability to pass in later life. Subsequently, it suggested it may also improve image and well-being. But then this is subjected to a systematic review, paragraph 81, and paragraph 82, no changes in gender dysphoria or body satisfaction were demonstrated, insufficient, inconsistent evidence, etc., etc. That's just showing you how a thing that was thought to be time to think, that was the rationale for the Tavistock, really on the evidence assessment, turned out to be, and of course we know now those...
Well, I mean, 83 is very relevant, really. There's no evidence that really it did give you time to think, because you went on to hormones in those cases. Yeah.
Thank you. 214, so over the page. This is the review of masculizing and feminizing hormones, so gender-affirming hormones, and overall concluded there is a lack of high-quality research assessing the outcomes of hormone interventions in adolescence, and few studies that undertake long-term follow-up. No conclusions can be drawn about the effect on gender dysphoria, body satisfaction, psychosocial health, cognitive development, or fertility. Uncertainty remains about the outcomes for height, growth, cardiometabolic and bone health. Suggestive evidence of that hormone may improve psychological health, although robust research with long-term follow-up is needed. Just, again, the uncertainty of the evidence base. 215, if I may, is challenges in clinical decision-making. This is a reference to some of the Bell and Tavistock issues, and in particular,
which paragraph?
Paragraph 98, assessing whether a hormone pathway indicator is challenging, that the diagnosis is not predictive whether the young person will have long-standing incongruence in the future, and 99, poor evidence base makes it difficult to provide adequate information. On to 101. Although young people often express a sense of urgency in their wish to access medical treatments based on personal experience, some young adults have suggested that taking time to explore options is preferable. The option to provide masculizing, feminizing from the age of 16 is available, but the review would recommend an extremely cautious clinical approach and a strong clinical rationale for providing hormones before the age of 18. This would keep options open during this important developmental window, allowing time for management of any co-occurring conditions, building of resilience, and fertility preservation if required. That's where you get the extreme call, and that gives rise to the recommendation on the following page, recommendation 8. In the right-hand column, and recommendation 9, the importance of the multidisciplinary team review, and recommendation 10 about the importance of fertility.
So recommendation 9 is the one that the private clinics cannot comply with.
Well, we say they cannot comply with it. There's no external second independent opinion.
Yeah, is that common ground, that they can't comply with recommendation 9?
I don't know if it is common ground, but it should be common ground because there is no means. They can say, oh, but we discuss it internally and we have different specialists. I'm sure that is true. They will have different specialists. But there is no evidence for the court that there is a second opinion for an independent provider. Mm-hmm. If I may, 215, if I may, about...
Sorry, what page?
Sorry, it's my mistake. I think my notes is 215, where I'm looking for... Excuse me a moment. Yes, sorry, paragraph 97, third line, on the right-hand column of page 215. Third line, however, consent is more than just capacity and competence. If intervention it requires clinicians to ensure that the proposed intervention is clinically indicated, as they have a duty to offer appropriate treatment. It also requires the patient to be provided with appropriate and sufficient information about the risks, benefits, and expected outcomes. That's the, it's not two sides to the capacity and consenting process. There's a mention of private, in particular, page 225, as to one of the recommendations. Recommendation 26, on the right left-hand column, is that the DOH, Department of Health and Social Care of NHS England, should consider the implications of private healthcare on any future requests for treatment, for monitoring and or involvement in research. This needs to be clearly communicated to patients and private providers. I don't want to go down a cul-de-sac on this, but if I may just say that an interim service specification came into force post-CAS, and in relation to the interrelationship between private care and my Lord Justice McFarlane would have seen this in the case of EF, that the policy was or is that if you go down the private route and start not in accordance with the NHS plan, then you may not be eligible for treatment on the NHS. It's sort of a disincentive to use private provider in that way. 259, if I may, is the recitation of the Bell salient factors under, I'm now in this section,
Wider context.
Under heading wider context. And I apologise for a moment. Yes, right-hand column 4.6, a summary of the salient factors in relation to puberty blockers, and I take the Master of Rolls' point that it was puberty blockers with a view to hormone treatment. But these are some of the matters that were considered to be salient. I just allude to it as that will be part of the capacity assessment, whether these sorts of matters can be properly weighed and considered or used, retained for the purposes of decision making. At 4.10 of the report, our page 260, this is a repetition of a point I've already made, so that's unnecessary, but is that there's the ability of the child or young person to lawfully consent to the proposed treatment is only one issue. There are two other issues to be addressed: the judgment the clinician makes as to whether the treatment is indicated for a patient, and the information they provide to them about the potential benefits and risks.
That's a sort of doctor's way of looking at it, because
Yes.
we would say that as lawyers, we would say that the two other issues are essential to the child consenting. First of all, the child has to be offered the treatment, which necessitates a clinical judgment being made first that it's appropriate. And secondly, the child has to have explained to it the ramifications of the treatment in all full detail, and it's only then that lawful consent can be obtained.
Indeed.
But I mean, Professor Cass is a doctor, and I understand, but I think it's important for us to realise that those two are essential parts of the consent.
Yeah.
And you see, what troubles me about all this is that, and I want you to have the real opportunity to deal with the point that troubles me anyway. In Bell, we said, all this is for doctors, right? And we perfectly understand, I think we said it 3 times, how controversial and how incredibly strongly held opinions there are on both sides of the debate. But we said the court is not best equipped to make general assessments. It's about, as you said right at the beginning, it's about the facts of each particular case, and it's for the doctors to make the decision and to obtain the consent, the Gillett consent it was in that case, but whether it's to overrides to decide, and then, only then, on proper legal grounds, would the matter come to court. Now, what you're saying is, I mean, the extreme of your argument is we should say this is now a special category because of this report, really, and it's so serious for any child's future that it shouldn't be done without the court. But if you're wrong about that, then for all the same reasons, the case should not have been adjourned because there is a dispute and because the mother is entitled to keep a track on what's happening here. But what Bell said was effectively, well, this is for the doctors. Come back when you've got a decision you want to question or say is unlawful.
I've ventured one answer to that, which is the distinction between the Bell decision, the court's not an advice centre in general terms, but come back with some facts. And I say, we've got facts.
But your facts, I mean, this is why I drew attention to Ms. Munro's skeleton. The facts are, at the moment, not indicative that it would be appropriate for the court to intervene if all the hoops were jumped through. But you say not.
I say not, and we certainly don't know that. You shouldn't, or the judge should not have foreclosed proper review or audit of the process.
I mean, the key thing you criticise about the judge is that she said, I always use the wrong phraseology, but she said she couldn't envisage circumstances in which she would interfere if those hoops had been gone through. And you say that was wrong.
I do say it was wrong, yes, because I've sought to show by reference to Cass what a jolly difficult decision it is, and the court in its protective function should be very slow to be satisfied that such a decision is being properly made. Certainly, if extreme caution is recommended.
I mean, one of the quite compelling things to me is that on the NHS, this person could never be referred until 18 at all.
That is the current situation.
So I think you're saying, aren't you, that, just set aside your special category for a moment, that if this was NHS treatment, then you couldn't get over Bell. But this private provider, where they couldn't have the treatment anyway on the NHS immediate steps, that Cass is critical of the model that they're going to govern themselves by, that there isn't the external check, that there is no quality assessment or approval of their assessment process, and there's severe criticism of the board that gave them their authority, if you like, for the provision of the drugs, that in those circumstances, if the assessment was to take place, which the mother agreed could, the court should have adjourned. Because it wasn't going behind Bell, it was saying on the facts of this case.
Lady, that's absolutely right, because I accept if it was, mother agreed at an early stage that if it was through the NHS, she was in favour of that. But the problem has been we're not in the NHS, and that is why the Bell determination doesn't have the consequence that all the Master of the Rolls is saying, that you're just coming for an advice, you're just repeating that argument, because we are factually distinct for all the reasons.
Because what you're saying is if when the methods and way that assessment was handled came before the court following an adjournment, either then it would be Bell done, that those concerns about the provider were satisfied, or you might argue it was one of those rare cases where the residual jurisdiction following Section 8 would
Exactly.
That may be difficult in possible, whatever, but I'm just trying to work in my mind the structure
That
you
is
say
the structure.
allows you to, if there isn't a special category, to comply with Bell and still get the outcome you want, namely there should have been an adjournment.
That is, I think, it's how I've tried to put it in Scones, and if it didn't, but thank you for clarifying it in that way.
Clarifying
that
for
is-
me.
And I suppose you say, actually this is not a prohibited steps order case anymore, it's an inherent jurisdiction case. And my lord explained to me this morning, if I can disclose, gave me a short lecture on the subject of how those two interact.
No PowerPoint.
And without PowerPoint. But it's an inherent jurisdiction case, and the court should not close the case down, which indicates there's nothing to see here, because Cass has said there is something to see, and the private clinic has not got a complete green light to everything it's doing in the light of Cass because of the separation of the paths of the private process from the NHS process. That does give the court something to consider potentially, but possibly in the future. But as my lady says, it could be it comes back and it's all fine and everybody agrees, or not. And it's not a big thing to say adjourn it rather than close it down. I mean, you would say, right?
Exactly.
Yeah.
You're going to take us to the judgment. I don't want to jump ahead, but it's paragraph 60
Yes.
of the judgment. This is just part of the judge's reasoning leading up to her decision. It's in paragraph 61, so we know what she goes through. But it's paragraph 60 where she does or doesn't engage with these factors. She says the controversy over treatment of young people, whether privately or through the NHS, gender-related distress, is a matter of public interest, but it is something that should fall to be considered by medical and associated professionals and their regulators if need be. And then she says it's a private clinic, but it has registration for the hormone side, and also those treating would be subject to any negligence action. So that's what she says there. Your case, I think, is, yes, that's in line with Bell, but in this interim period, which may run for quite some time, post-Cass, where the red flags have gone up about all this, it's not sufficient for a judge dealing with a particularly young person at that particular time to abdicate her ability to audit, my word again, what's going on while it goes on, rather than simply saying this is not for me, it's for the regulators and the NHS. And that if you're looking at where the judge might have fallen into error, these points all feed into paragraph 60.
My lord, they do. And again, I'm very grateful for the articulation of that as a potential error or arguable error that the judge.
I'm not saying I agree with what you said, but I think that's with
that
the
is
judge's
certainly
judgment.
Well,
that is certainly the argument.
you would say that is not second guessing the doctor making the decision, but it is in the light of the uncertainties that are new, actually, the uncertainties and the discrepancy between private and NHS treatment, which is opened up since Bell, completely new, and Cass, completely new. It would be. It's not really that it's irresponsible. It's that there is something potentially for the court to ensure or supervise is done properly, bearing in mind those discrepancies. Probably wouldn't have been in Bell, but anyway, Bell wasn't a case on a particular set of facts, and this is, and you say there is serious, entirely bona fide dispute between the parties holding entirely proper opinions but different opinions, and therefore the court should not stand back and say it's nothing to do with me.
Indeed. That's it. And by dismissing the proceedings, effectively closing out.
It would help me, I know you're very short of time, but it would help me if you showed me the passages in the two cases you referred to earlier. You don't need for me to go to Bell. My lord didn't have the great pleasure of being in Bell, but we did, and we're pretty familiar with it. But to show me the other cases that you say bear on that point.
Yes, the role of the court and its protective function.
Exactly.
Yeah. May I do that? And I'm going to come to it. I will finish before lunch.
Okay, well, just quicker you get
Have you
on
finished
with
with Cass?
I had only two more, I think 2 or 3 more short references. May I do that?
Give them to us, yeah.
Briefly. Just to say at page 365, there's the note to the effect that that no study had assessed fertility in birth-registered females. I'll have to get my front page for that. And that is further expanded within the document at 15 I'm reading from the last sentence of 15.20 on page 365.
Yes. No study assessed fertility in birth-registered females, yeah.
Still in chapter 15, at 15.43, is a summary. In summary, the evidence does not adequately support the claim that gender-affirming treatment reduces suicide risk. However, the distress is real for these children, some of whom hold strong beliefs about the efficacy of both. This will be exacerbated by long waits to be seen in specialist services, etc., etc. Thus, fear that delayed access to medical treatment may lead to suicidal thoughts remain high in parents, and this is regardless of how effective they may be. It's just acknowledging the associated risk, but saying that the suicide risk is not demonstrated on the evidence. The chapter 16, which is the section dealing with at page 377, I can just give you a handful of references for this. This is within the context of best interest decision making. 16.14. There's a point about the unknown benefits of the indicated use of puberty blockers and masculizing and feminizing hormones are unproven and benefits harm unknown. At paragraph 1625 to 1628 is a summary of competency, capacity, consent.
Sorry, where are we?
Page
Oh, got it,
376,
thank you.
right-hand column, and a summary of the sort of legal position. I don't think anything particularly turns on that. 16.32 is the best interest decision making and how that should be gone about. 16.37, a repeat of something I showed you earlier on, that some people have said taking time to explore is preferable. And 16.39 is the detailed, but something I've shown you before, extreme caution, extremely cautious clinical approach. And
we're all conscious you're taking us to particular paragraphs that are very supportive of your position. And there will be other paragraphs we haven't seen. I'm conscious of that, and we need to.
may I just leave with one?
But certainly, those paragraphs are there, and this report landed. Was it a week before the judge?
I think a week before. It prompted some further submissions in the light of it.
And it goes back to the point I made a short time ago, was that for this child at that time, the judge may have had a particular responsibility to keep the matter under review, because it was all up in the air, at the very least.
Thank you. May I leave just with 16.23? It's a point I raised and I sort of read out, noting it, so I referred to it. Our page 376, 16.3. This raises the question whether those in late adolescence and not on puberty blockers, so our case, managing any mental health problems, ensuring participation, etc., organising facility preparation if required, are more pressing issues than commencing fertilising. So all those issues up in the air. So that is essentially the end of my CAS references. Can I now try and epitomise my arguments? I've tried to answer questions that I've gone along on the grounds. I'm really following through the argument as made under paragraph, sorry, it's my skeleton paragraph 9. We say, essentially, for reasons already articulated, should have waited at least until the gender plus assessment because of the reasons I've given. I don't want to elaborate on that point given the time, but it's been articulated by my Lady Justice King and Lord Justice McFarlane as to reasons why that might have been material in the judge's mind at a particular time and that it was premature. I've made the point that capacity in a vacuum is really meaningless. You need to take a specific decision, and there are two sides to that, giving the right information and being able to understand and weigh it. May I just make this point and then deal with the cases briefly? What if, it's certainly a possibility, I suggest, that the court might say, given the very difficult, when you look at the salient factors and given how difficult the decision is, it might not be possible for the individual to give informed consent. And in those circumstances, the best interest decision would have to be made. And that feeds into arguments about how can you understand things like loss of fertility, potential loss of sexual function, experiences that you have no real conception of at the age that you are. But even if you're against me on that and say, well...
It slightly goes back to divisional court bell, that, doesn't it?
It does, yeah. But even if the bar is set low, my main point is that surely, given the backdrop of CAS identified, that's not the end of the court's role. The court does have an ongoing role. And so you say, well, where does that come from in terms of law? And I point to what I'm calling the override. And to make that point, may I just briefly turn up the Authorities Bundle Volume 1 and deal first with a case called Re A, that's tab 3. This is within wardship, where the case was a 15-year-old girl with mental illness.
Sorry, I need to find it. You say it's tab Rea minor.
135.
Got it? Yeah. Rea minor, yeah.
Decision of the Court of Appeal in wardship concerned, I'm not going to even read the head note, can I just even epitomise that? A case, 15-year-old girl, mental illness, fluctuating capacity, but when lucid, was refusing treatment. So it was overriding a capacitous refusal issue. If I may turn to the held at R page 136, report page 12 at C, the court in the exercise of the wardship jurisdiction was entitled to override a minor's decision either consenting to or refusing treatment, irrespective of his or her competence, that in any event, having regard to the fluctuating nature of illness, I was not competent to give or withhold her consent. And then within the judgment, if I may go to page 28 of the authority, our PDF page 152. At the bottom of the page, when Justice Staunton's judgment between G and H, second sentence in the penultimate paragraph, I conclude that the powers of a wardship judge do indeed include power to consent to medical treatment when the ward has not been asked or has declined. That means the wardship judge has wider powers than a natural parent. I don't express opinion on that. It seems to me to be warranted by the authorities to which I have referred. And then going on to the next page, the converse, bottom of the page, the converse in wardship, where the ward consents, but the court is minded either not to consent or positively to forbid treatment. So the nearest analogy to our situation. Does the judge in such a case have an overriding power to which the natural parent of a competent child under the age of 16 does not have by reference to Gillett? If so, there would again be a problem for doctors. But the trend of the case seems to show that if the treatment would constitute an important step in the child's life, the court does have that power. So in the context of wardship. The next case in re W is an inherent...
Just to decode that, the wardship court, generally, if the child is a ward of court, if an important step, and it might be changing school, doesn't have to be life-threatening, would require the leave of the court. So the fact that he uses that phrase doesn't mean that all medical treatment issues have to come to the court. It's under wardship, and that's not just the inherent jurisdiction. It's where the court has parental responsibility. That is the structure.
That being the nature of the machinery of wardship entirely. And I was hoping, I'm not trying to make that.
No, I'm just really...
Now that was for the instruction of the Master of the Rolls, I think. And it's duly noted.
Lord, may I turn to re W? And with relation to re W, may I try and take this, again, head note, succinct and accurately describes the case, anorexic child over...
Right, is this tab 4?
Tab 4 of the authorities bundle.
Thank you.
Page 157.
Thank you.
Anorexic child over 16. Treatment against the wishes of the child. This is the... I take to the held first. Dismissing the appeal, F to G, that on its true construction, Section 8 of the Family Law Reform Act did not confer on a minor who had attained the age of 16 an absolute right to determine whether or not he received medical treatment, but enabled him, the limited person of protecting his medical practitioner from prosecution or any claim in trespass, to give consent to such treatment as effectively as if he were an adult. And going on to between G and H, talking about the increased importance of his wishes as he gains maturity. Last few lines of the court is related to the court. The court would override them, as to say the child's wishes, where his best interests so required. And that having regard to the nature of W's illness and to the serious deterioration of condition, her best interests required the court to direct an immediate transfer to the treatment. That's the initial just points to note, if I may, from the decision. Firstly, in terms of the argument that is deployed, I simply note it's using the numbers in the report of PDF page 163 between internally on the page 70B to E.
The argument of Mr. Munby.
The argument is summarised of Mr. James Munby, Queen's Counsel, as he then was.
Mr. James Munby, Queen's Counsel, I suspect.
Sorry, Mr. James.
I think that's what you said.
I thought you said sir, sorry.
Sorry. Between B and D, this is the argument. It's reproduced later in the judgment. But I simply note the emergence of the special category discussion, because he argues a middle course between two approaches are that a judge exercising inherent jurisdiction in relation to 16 or 17-year-old child should ascertain the child's wishes, and B, in cases involving normal surgical, medical or dental treatment, the child's decision should determine what is in the child's best interest. In other words, if it's normal treatment, the child's decision is final. No role for the court. Now that's ultimately rejected by the court. But goes on to say, such a court gives effect to the fundamental principle of self-determination, etc. then says at C, extraordinary cases will fall into a special category. They include cases where the child proposes to submit to sterilisation, abortion, organ donation, or some similar non-therapeutic procedure, or where the child refused to submit to some procedure necessary for saving life, etc., etc. So the origins, if one, I'm sure there are examples before that, but certainly of the emergence of a special category concept emerging in the case. At 81B, if I may, between A and B, a point I've already touched on, but simply to note between A and B, the feature, fourth line, of anorexia is it is capable of destroying the ability to make an informed choice. I seek to draw an analogy, it may be imperfect, but between the nature of gender dysphoria and the ability to make an informed choice about taking hormone treatment. The 81H, this is within Lord Donaldson's approach, talks about good parenting and so on. Bottom of the page, welfare interests of the minor, self-evident, this involves giving the maximum degree of decision-making, which is prudent. Prudence does not involve taking all risks, avoiding all risks, but does involve avoiding taking risks which, if they eventuate, may have irreparable consequences or which are disproportionate to the benefits which could accrue from taking them. And in the background of the Cass review about exiguous evidence of actual benefit in terms of long-term outcomes, medium-term outcomes, that's relevant because the nature of the treatment has irreversible consequences and, of course, may later be regretted. 83G, I'm still in Lord Donaldson, and now the summary of his determination or findings or ruling or judgment at G. Number 4, Section 8 of the Family Law Reform Act gives minors who have attained the age of 16 a right to consent to surgical, medical or dental treatment. Such a consent cannot be overridden by those with parental responsibility. It can, however, be overridden by the court. That court function, I say, is part of its protective function, which is recognised in the authorities. In Lord Justice Balcon's decision, which I believe is starts at page 84 of PDF 177, there's the 84G to H. Same point about anorexia that Lord Donaldson made between A and H. Looks, and I say that because he looks at the underlying facts before turning to what he describes as the issues of law which arise on this appeal. And what I hope to show, briefly at least, is that the two issues are, is there jurisdiction to override, and what should the approach be? And those are both legal issues as identified. At 85G, the Section 8 is reproduced. The ultimate decision is, you can see, or the reading, his interpretation of it is at B at 86. The purpose of the section is clear: to enable a 16-year-old to consent to medical treatment which, in the absence of consent by the child or its parents, would constitute distress. In other words, purpose, and for this purpose only, a minor is to be treated as an adult. 88A to F flowing from that no complete autonomy, there's no overriding limitation to preclude the exercise by the court of its inherent jurisdiction, and the matter becomes one of the exercise by the court of its discretion. Nevertheless, the discretion is not to be exercised in a moral vacuum, and then goes on to explain underlying philosophy of the Act. And then between C and D, explaining that in one sense it's merely the application of the welfare of the child as the paramount consideration, Children Act, normally in the best interests, aged understanding to make an informed decision the court should respect its integrity as a human being and not lightly override its decision. Running on to, he will start with at E, a strong predilection to give effect to the child's wishes. But if the court, nevertheless, at F, if the court's powers are to be meaningful, there must come a point at which the court, while not disregarding the child's wishes, can override them in the child's own best interest objectively considered. And then gives an example. And so that's the power of override that is there and can be, is available to be exercised. If I could pick up Lord Nolan, at C, the question of principle raised by the appeal is whether, and if so, on what grounds the court has power to overrule the refusal. So again, two questions: is there jurisdiction, and if so, how should that? What's the correct approach in law? Which I say is our case at 93. B, after a repetition of some of the authorities, 93B, we have just under B on our PDF page 186 at B, they, as is the House of Lords, that's talking about Gillick, were not concerned with the jurisdiction of the court. It is of the essence of the jurisdiction that the court has the power and responsibility in appropriate cases to override the views of both the child and the parent in determining what's in best interests. Bottom of page 186, last 5 lines between G and H, using 186 as the PDF number. In considering the welfare of the child, the court must not only recognise but, if necessary, defend the right of the child having sufficient understanding to take an informed decision to make his or her own choice. In most areas it would not be wrong, but also futile for the court to adopt any different approach. In the area of medical treatment, however, the court can and sometimes must intervene, and again that's the reference to the protective function of the court. And then looks at Mr. Mumby's categories, which were reproduced by Lord Justice Nolan, on our PDF page 185 A to D, and you'll see that number 3 was the extraordinary special category, and 4 was included might be, for example, submitting to a sterilisation or abortion or removal of an organ. So those are examples of his. And what Lord Nolan says about that is, at between A and B, PDF page 187, I do not, for my part, find it particularly helpful to speak in terms of special or extraordinary cases as distinct from normal cases. Apart from that, however, I would broadly accept Mr. Mumby's 3rd and 4th proposition, so that's those special circumstances. One must, I think, start from the general premise that protection of the child's welfare implies at least protection of the child's life. It goes on, and then next at D, to take it a stage, last line at C, going on to D, it's the duty of the court to ensure, so far as it can, the children survive to attain that age, that is 18. To take a stage further, the child's welfare is threatened by a serious and imminent risk that the child will suffer grave and irreversible mental or physical harm. Then once again the court, when called upon, has a duty to intervene. And I rely on that passage because I say suffer grave and irreversible physical harm is a reasonably foreseeable consequence of undergoing gender-affirming treatment if that is later regretted because it's taken at a time while the child is either his decision-making is overborne by the desire for treatment such that it's not a truly informed consent, or because, having capacity, it's not a decision in his best interest to start that treatment under 18. So those are the source of the override. I say, but without turning it up, that in NHS and X number 2, which is our tab 20, which is the Sir James Munby decision, in NHS number 2 at paragraph 84.
Page number.
Sorry, I can give you the page number.
Sorry.
It begins at 695.
Thank you. Yes.
May I just observe that there's a detailed analysis of some of the law, and I don't think it's necessary for me to go over it. It's only to note that paragraph 84, page 715 of our PDF, Mr. Justice Mumby, sitting as a High Court judge, Sir James Mumby, sitting as a High Court judge, said, "I conclude, therefore, that there is nothing in the Mental Capacity Act which throws any doubt on the continued validity of RA minor and in re W, nor indeed anything which even begins to suggest the need for any judicial re-evaluation of what they establish." Simply to say, within that case, it was being argued that landscapes change. Mental Capacity Act means that the child's decision is determinative, and that is effectively rejected in that case. In terms of other authorities, I'm not going to take you to Sidaway or anything like that, but I think it's in the bundle. But the informed consent really talked about by Lord Scarman and Sidaway as finally it finds its full life in Montgomery in 2016. Within that decision, just to emphasise why the judges in Re W were talking about battery in the way that they were, there is a passage, and I'm not going to ask you to turn it up, but it's, if I give you the references, 894D to G, where there's a discussion of battery being a state of mind, and there's the phrase, I think it's Lord Diplock saying, either you know it or you're stopped in relation to battery. The only reason I'm mentioning that is because when you look at Re W, they were looking at consent and the Family Law Reform Act in the context of a legal world where the informed consent as per Montgomery did not form the general state of the law. And Bolam, the doctor judging what needed to be told to the patient, was the law. Special category.
I mean, you say, just before you finish on this, that what Mr. Justice MacDonald said in GK doesn't in any sense override what you're saying about the ability to override the decision made even by a capacitous child.
Absolutely correct. The passage is reproduced. I think it's in the first respondent skeleton. It may be the second.
I think it's in the Guardian skeleton where the summary is that until the child reaches the age of 16, the relevant inquiry as to whether the child is Gillick competent, and afterwards Gillick competence falls away and the child is assumed to have legal capacity in accordance with Section 8 unless he's shown to lack mental capacity under the Act.
And none of that changes.
None of that changes Section 8. You say the ability to override Section 8 in accordance with these authorities.
Correct.
Right, good. You wanted to say something about special category in 1 minute, or do you want to come back after the short adjournment for 2 minutes? Never refuse an offer like that, Mr. Never.
I'm not going to refuse the offer.
No.
May I come back after lunch for a handful of minutes?
Very good decision, Mr. Hine. 2 o'clock.
All right, please.